correctional facility, and he could potentially be in GP. Now, the problem with that is, his trial was seen all over the world. So I'm pretty sure that every prison, and including the inmates, knows this man.
Wisconsin
Oh, here
versus
we are.
Darrell
Here we
Brooks,
are.
case number 21 CF 1848. May I have the appearances, please?
Morning, Judge Sue Upper, Leslie Basie, and Zach Witchell appearing for the state of Wisconsin.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all my rights here this morning.
All right, so wait a minute. If he doesn't dispute the facts, then why don't he just say that I'm guilty? You're not you're not disputing what the evidence is against you. Just say, listen, don't you know this whole trial could have been, it wouldn't even have been a trial if he would have just said that I'm guilty. That's what he said. That's admission. You don't dispute the facts. All right, well, put him in jail. Let's get right to sentencing. We ain't got to need no trial. He just admitted by his own admission. All right, come on in.
All rights reserved.
All right, good morning to you as well. The records reflect the individual known to this court.
Mr.
Darrell
Brooks
is present in person in custody. However, he is wearing street clothes, a suit and tie, and a mask.
And for the record, I don't consent to being called that name.
Okay, Mr. Brooks.
It is noted. All right, Mr. Brooks, just preliminarily, do you anticipate calling any additional witnesses today?
For the record, I don't consent to being called that name.
Okay, Mr. Brooks.
Do you anticipate calling any witnesses today?
I don't believe today.
You stalling.
Well, we are here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
Oh, Lord, here we
I
go.
haven't looked.
Why don't he go see the clerk of courts? That's who handles that. What does that? Watch this. What does that have to do with him calling?
Actually,
Who is he going to call?
And then one to the prosecution.
What does that have to do with the question that she asked him? She asked him,
Is the audio on?
It is.
Is he going to call as his witness?
The audio's on.
And you see, and the judge fell right in his trap because she didn't ask him that. She's doing something completely other than what she asked him.
Do you know
And
when
so
you sent those?
Saturday.
This is further stall, further delay.
So that would have been the 22nd.
State receive anything through like the inter-office communication?
We have not. I just checked this morning to see if there's anything new. Nothing has been received at my office.
This is really irrelevant.
And
He
I
needs to
should
be.
say the clerical that was assisting me went to the mailroom to double check.
Yeah.
So
check
not
with
only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
Go to the clerk of courts. That's who handles
I
that.
can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state.
No objection.
From you, sir?
No objection. I definitely want those documents received if they obtain important information.
Whatever.
You said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
And those are two ICF forms?
Yep, one addressed to you directly and one addressed to the district attorney's office.
Now y'all know it's something frivolous. Something stupid. I can't believe he's talking about ICS and she didn't ask him that. She asked him about witnesses. What in the world? This is a waste of time. The clerk of courts needs to be handling this, Judge Darrell.
I'm sending that. I will send it with high importance and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
Yeah, what is it?
The topic is pertaining to exculpatory evidence. Some things were learned.
Okay, so exculpatory means apparently he's suggesting that he has something that will refute what's being pinned against him or alleged against him. All right, here we go.
And once they came to my attention, I felt the need to immediately address the court about this information.
Right? What information make enough of proof?
Yeah, what do you have? Be
sir?
specific, speaker.
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle.
Oh. Schultz.
Officer Ryan Schultz.
Uh-huh.
Question was asked
Uh-huh.
of did he know if there were any recalls on that vehicle.
Apparently not if he did the inspection.
And I believe that
There wasn't one on there.
A Brady claim should be visited because there were in fact recalls on that vehicle.
That's
in
a
fact,
lie.
There were recalls on the Ford Escape models from 2008 through 2010.
Yeah, just like you was riding in a tan Kia, whatever it was, whatever that lie. As a matter of fact, y'all remember? Let me take a little. Let me ask y'all a question. Do y'all remember when Detective Carpenter was being questioned by Brooks, and Brooks was trying to frame him as a liar? Remember, he was like, "So you basically lied," and then Detective Carpenter got him back. He said, well, you lied about being in a tan Kia. You lied about your mother not owning a vehicle. You lied. And then the judge had to stop him. Yo, because Detective Carpenter was reading him the riot act, and I loved it. Because Brooks tried to frame him as lying in the interrogation, and Brooks was lying through that whole entire interrogation. So how is the kettle gonna call? Come on now, the pot black. So come on, man. Don't try to act new. Don't do this. Don't do that. Don't do that. And so he ain't doing nothing but doing the same thing right here. Lying about a recall when the vehicle in question was in fact, inspected by Ryan Schultz. So what's this exculpatory evidence he got? What he got going that's gonna refute what Inspector Schultz got? What, speculation? That's your evidence, speculation? Versus the evidence from the inspector? Man is stupid, just as dumb as they come.
In regards to the throttle body malfunctioning
Ain't nothing wrong no throttle.
and causing the vehicles to accelerate and not being able to be stopped.
Liar.
There is a class action lawsuit where Ford company were
Liar.
sued because of this.
Facts
and
not in
those
evidence.
vehicles, models from the year 2008 through 2010 were
Liar.
recalled. And
You liar.
that is very important information in regards to the vehicle in question being
Liar.
a Ford Escape 2010.
All right. Can we hear from the state?
This information is very easily obtained.
No, it ain't.
Just by pulling it up, and you will see a class action lawsuit.
By
Obviously,
speculation.
if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
Right.
My request is to find out if Officer Schultz knew to find out if
He did the inspections.
prosecution knew that there was a recall on those vehicles?
That's not.
And in light of the the fact that these vehicles were recalled
They were not. What are you
because
talking
of
about?
this malfunctioning throttle body,
He is actually
for
sitting up here lying. He told the jury this
I
crap
believe
too.
it's
Y'all remember that? They had to stop him. Stop.
counts 1 through
Objection.
73 to be dismissed.
Paul, she is not dismissing no case over speculation when they got evidence from a real inspector. She ain't this. How dare you think you can get this dismissed off of speculation? Nah. That's what you talking is facts, not in evidence. Or should I say lies that are not of evidence? They ain't dismissing this. Is he nuts? I know his mother's crazy and the apple don't fall from the tree, but damn.
All right,
Shoot.
what's the response from the state defendant?
Thank you, Your Honor. As Trooper Schultz testified during his
Exactly.
examination, consistent with our research, there are no active recalls listed for the
Exactly.
Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old. It has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report.
Exactly.
There was no recall in the throttle body.
Thank you.
NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall
Exactly.
or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here.
And it didn't.
Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car.
Exactly.
Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the
It wasn't no light.
indicator
didn't
lights.
come on.
None of them were lit.
Right.
Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report.
Right. So where's
Therefore,
Darrell?
this is, although there may have been some cars who had this problem,
But it wasn't
the car
that one.
that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway
Right.
Traffic and Safety
Yo, the state.
Administration.
Listen, y'all. The state did their homework on it. It's almost like they overdid their homework on this case. They had everything strategically down. Like, I mean, everything. Yo, they shut Darrell Brooks down, man. They're basically just debunking his speculation with facts that are in evidence.
There are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls.
Wow.
So it's a mood issue.
Exactly. Now, let me ask you. Let me say this to y'all. Now, he just said before the prosecution rebutted. Now, he said that he had exculpatory evidence. And as I told you before, exculpatory evidence means that you have a piece of evidence that refutes what's being alleged about you. But how can what he has be exculpatory if it's speculation? So how can speculation refute facts? You didn't hear me. You didn't hear me. How can speculation refute facts? So what's so exculpatory about it when it has nothing to stand on? Come on, man. Come on,
I
man.
believe it's legal.
You came to a gun night. You came to a gunfight with a knife, a butter knife at that. You brought a butter knife there. You got your little butter knife. You got your little butter knife. But they got ammunition, man. They got ammunition. And they shut you down.
Issue, and I actually have the report should be in the mailroom as we speak. I had everything sent over priority mail. The actual information about the class action lawsuit, the actual information about
Nah, you got
the
nah, man.
recalls for those models. Like I said,
A lie.
2008 through 2010. Now, in all fairness, Your Honor, that's
Make
why
up a
I
lie.
was asking for a Brady claim on this.
How? Wait a minute. Why is he asking for a Brady claim? That means the state is withholding information from him. How are they withholding information in light of a Brady claim? When she just read to you everything about this vehicle that there is no recall. So there is no, they're not withhold. They just told you Inspector Schultz's report. How is that a Brady claim? They exposed the information. They did not withhold it. Oh, Lord. Lord, Lord, Lord.
Seeing is how
Lord, Lord.
when vehicles are purchased from the manufacturer, they're still sold as is.
That's lame,
There would
man.
be no way to know
That's
that
lame.
there's anything malfunctioning with the vehicle until it
So,
actually happens.
so if you don't know, then that would be speculation, right? You just said there's no way to know. So if you don't know, then you're speculating. What I'm saying is Attorney Baisley has facts because there was an investigation, or should I say, an inspection of the vehicle. And so they know. You're speculating. Man, there's an honor, an honor, fool.
And
And shut up, because you ain't making sense.
seeing this a class action lawsuit,
There is no. Oh,
no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit
that's the wrong model, man.
if these vehicles were not malfunctioning.
It's the wrong year.
And
It
I
wasn't your
believe
vehicle.
with that, like I said, the information is easily
The
obtainable.
speculation. The speculation.
I should have the information in the mailroom
You
right
mean
now
speculation?
that you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question. It was 2008 through.
Now wait a minute. Do y'all notice he said it's in the mailroom? So if that's so important, then why didn't he bring that with him? See, watch this. Sue Opper or Attorney Basie, they had all their information right there in the courtroom debunking him. So now he's talking about something that's in the mailroom. See? What are you talking about? Where's your proof? Make an offer of proof. No different than you saying that you had pictures, but you didn't bring the letter. Come on, man. Where's your proof? You're not making sense. The judge is not going to rule in favor of speculation and dismiss the facts. This dude, oh my God. What a nerve. What a nerve. What the, oh my.
2010.
Come on, shut
The
him up. Shut him
information
up. He's
about the
lying.
malfunctioning pertains strictly to the throttle body.
Lies.
Let me address your claim,
Yeah,
sir.
yeah, shut him up.
So, not trying to cut you off, I don't need the specifics about a class action because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state.
Exactly.
In fact, you even indicate it was readily known and something you were able to find out.
Right.
I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems.
Exactly.
Because, again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls. And more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it.
He sure did.
I am aware that the ICF, I did receive an email. It's one page with what you said. I have to turn my head. I got to figure out how to flip it. So give me a second.
Okay. And just for the record,
shut up.
Let me finish my record, okay?
Yeah, shut up.
So I'm going to turn because it's the only way I can read. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. So,
Yeah, but that's so vague.
I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do, and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof.
Wait a minute. Didn't I just say that? He said it was in a mailroom. Again, if that was so important that he's saying that it's so exculpatory, that will basically refute the state, then why didn't he where's his offer of proof? How come he didn't? Attorney Basie had hers. She had the report from Inspector Schultz. She made her offer of proof. Well, where's his? So that's what I'm saying. It's just speculation. I'm not believing speculation over truth or facts. What the hell?
She received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over.
He knew.
And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case.
Just like
I'll deny the request.
Subject matter jurisdiction denied.
Recall this witness.
Your Honor.
Hold on. Let me have the state just make their statement. I'll give you the last.
How you gonna come to court with no evidence?
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him.
Yes, he sure did.
Asking questions directly related to information contained in that report.
You sure enough
Go
did.
ahead, Mr.
When you spoke to the owner of the vehicle, that's who gave me the information.
Okay, so here we go. Now she's already ruled on it. She took the side of the state, which makes sense because they brought their offer of proof. They have an official inspection done by Inspector Ryan Schultz. He brings in speculation. So now he wants to challenge her on this. I don't know why you ain't bring your where's your offer of proof? You have none. You lost. It's over. So now he's mad because it didn't go his way because he decided to come to court in the absence of evidence and then try to make a claim. That's what it is. He's claiming that. We need to see evidence. You can claim anything, but if we don't see the evidence, then your claim is invalid and denied.
My mother gave me the information of this. I had no knowledge until she told me.
Too late. You a day late in the dollar short.
That's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court.
You a day late in the dollar short.
I understand that, sir, but your request is not timely.
It's too late.
So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record.
It was just,
Shut up and let her
just
talk.
told to me.
Shut up.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case.
Like a
the fact
fool.
that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but when I consider the information that you're providing to me, it's speculative
Exactly.
on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me.
Oh, shut up. You just said it was.
I don't have access to the internet.
Lies.
So how would I be able to...
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and
telling
I'm
you,
trust.
she just told me this information.
Okay,
I have
it's
the
too
phone
late.
calls to prove it.
I understand
late.
that I'm denying the request, sir.
And I would like a...
He
So
mad.
that's my decision.
I object to that, Your Honor.
I understand. I've made my
object to that.
decision. I expect that you respect the decision,
didn't
at
go
least
his
as
way.
we're not going to debate it further.
Yes.
I now have
He
the
mad.
It needs to be-
ICF,
it
the
needs to
one
be
from the state
addressed,
to be provided
Nah.
by the state.
It don't need to be addressed.
Madam
needs to
Clerk,
be
I just gave
addressed.
that to
Where's your
you.
offer of proof?
All right, so
I
Mr. Brooks, in
respectfully
light of
object.
that,
I respectfully object, Your Honor, and request the legal reconsideration of your ruling, Your Honor.
No. Why would she reconsider something you didn't even bring any evidence to support what you're saying, stupid? Why would she reconsider that? That's why I said you brought a butter knife with your little plastic knife. And the state ain't playing. They came ready. She ain't reconsidering that. And just because you mad, because you got debunked and made to look like a fool, going up against 3 experienced attorneys, you don't know what you're doing because of your ego. Won't make me flinch one, but look like you flinching now.
it's denied. The request for reconsideration is denied. There's no legal
Of course
basis
it's
for me to
denied.
I
do
He
that.
didn't have no
respectfully
evidence.
reject that ruling and take exception to that ruling, Your Honor.
Oh, please,
Mr.
shut up.
Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Be like your hairline. Denied. shut your mouth.
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue.
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter.
I wouldn't be the one you would make that request to, sir. So I can't
For the record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction.
That request is denied.
Based on what law or fact, Your Honor?
All right, we're
The
moving
request is denied.
Based on what law or fact,
We're
Your
moving
Honor?
Any
on.
other requests, sir? I'd like to move on.
Based on what law?
We're moving
There's no
on.
Or
legal
fact.
basis that you've stated for me to do that, sir.
We're moving on.
It has been, Your Honor.
No, it
The
has not.
request is
Shut up.
denied. The request is not a proper motion. There's no
That's 'cause you
legal
don't know what you're
support
doing.
for the motion. There's no factual support for the motion, so it's
There's no
denied.
hairline. There's no.
For the record, it
there's no
appears that
freedom.
this court is acting in contempt of the law, Your Honor. Can you show me
So you look-
how
see, listen.
where this
Now
court is
listen.
following the law?
Let me say this. Now she better than me, because see, at that point he would have been out of my courtroom because she's trying to move on. He just got debunked. Now y'all saw it. The state came ready. He was unprepared, and she took the side of the state. So now he wants to challenge. And furthermore, he's in the wrong venue to be challenging. That's for the appellate court. Wrong venue. So at this point, he should have been removed to the auxiliary courtroom because I'm trying to move on and he's being disrupted. She better than me on this. He would have been out of there. I wouldn't have him going through that sovereign citizen BS. And just like she said before, this is a common ploy. This is something he does commonly.
Respect in this matter?
That's a very vague
Very
statement,
vague.
sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact.
There's no freedom.
So this court cannot address that last statement of yours.
Your Honor, with all due respect,
Yeah, you're running out of words. You're running out
I
of
would
sovereign
like a-
citizen, girl.
motion for finding the fact.
Denied.
Under what law fact?
I
Your
made
Honor?
an oral ruling, sir. There's no requirement I do so in writing.
So you're denying a legal, you're denying a motion for finding the fact.
I am.
Exactly. What
So
you
how
gonna
do I
about
know
it?
what you're doing is legal, Your Honor?
Okay, Mr.
All right,
Brooks.
Mr. Brooks, we're going to move forward. At this time, I want to.
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward.
He's mad.
So
It
the
doesn't
request
seem
is
like it.
denied.
It doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and I'd
seem
ask
like
that
you're.
you
I
stop
don't need
interrupting
your
me.
advice.
No, I have to give you
I
advisements, sir, regarding your right to testify.
I need to do your job.
No, I need you to we need to get the sentencing so you can go to jail where you belong. You are mad because you were made to look like a fool. You got debunked, made a fool of yourself. And now you want to fight her back. And I don't know why the judge still kept him there. She had grounds to remove him at that point. She technically had grounds to remove him after she already made a ruling because attorneys don't argue with a judge on a ruling, or they would have been held in contempt. Well, in this case, she don't want to hold him in contempt because she don't want no further delay in terms of the inevitable. So she should have just had him in the other courtroom after this. She had grounds to do it. He's not supposed to be questioning her or challenging her on a ruling. What attorney does that?
Without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the
He's been
court's
doing
oral
that.
rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call,
Right, we're moving
I need
on.
to go through this particular discussion on the record with you regarding your right to testify.
See, he was expecting the judge to dismiss the case off of speculation. That's all that was, because he didn't have no offer of proof, nothing. That's what he expected. The judge to dismiss this with you killing all them people over something that you are speculating about? Bro, nah. Hell no. If she would have did that, trust me, I don't think Judge Jennifer Duro would have survived. Because the whole city would have been on her behind. Come on now. She wouldn't have made it out alive.
You have a witness to call, sir.
You don't need to go through anything with me on record.
Actually, I do so, sir. That is required by law.
Actually, you don't. You need to do your job as a public servant and honor the oath that you
I need to go through these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you will move to the next courtroom so that I can properly go through these advisements without being interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony.
Exactly.
So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I need
due
you
respect,
to not interrupt me.
This
is another interruption.
In Illinois versus
No.
Mr. Brooks, I'm not going to have a debate with you on the meaning of Illinois versus Allen. You are advised that continued
Illinois versus
No, get him out.
You are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but
get the animal out.
Saying that
I've said that multiple times. I've given you multiple opportunities to stop interrupting me.
You're holding me in
contempt.
Mr. Brooks,
this
I'm not holding you in
from
contempt for the second time here, and I've also repeated that. He's
Honor,
interrupting me yet again.
Get Dawn Woods' pet out of here. Get her animal out of here.
In Illinois
Shut
versus
up.
Allen.
No,
no. Continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court that he wants to disrupt these proceedings, even in a mild tone of voice.
Shut your mouth.
I've reminded him repeatedly.
Shut your mouth.
Because it doesn't.
Shut up. Illinois
versus Allen does not.
Get him out.
All right.
Get him out.
I'm going to remove him to the next courtroom so that I can go through proper
Get him out. Shut your mouth. Go to the other. Go to your cell. Go to your cell.
Cameras.
Go to your cell.
Again, I'll make the appropriate.
You go to your cell.
He is there.
Go to your cell.
Or that you
Shut
could be,
up, retard.
Or that you could be.
Shut up, mental.
So you're making a
mental patient. Take your medicine. All right, now we want to go over colloquy with the state.
By his own conduct, I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination.
Exactly.
So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have
Now wait a minute. Before she unmute him, it's almost like, now you know when she unmute him, he gonna go off. And now you didn't let an animal loose. Well, that ain't no different than what Dawn Brooks did when she went up there and bailed him out. What did she do? She let an animal loose.
Constitutional right to testify. Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Oh my God.
Mr. Brooks, do you understand and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
I don't hear you say anything. I don't understand what you're asking.
He is willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify,
Your Honor, with all respect, you've been trying
Did
to
you hear me say that?
answer questions for. I didn't hear you ask me anything. And I don't
Sir,
understand.
stop talking and I'll ask it again. Sir,
Can you ask me to stop talking?
Shut up! I'll tell
I'm
you to
asking
shut
you to
up.
stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do
I
this
got the
one last
headphones on.
time.
Yeah, I can hear them. I got the headphones on.
All right, then let's.
Obviously, you can see that.
Shut your
Once
mouth.
again, Mr. Brooks is being disrespectful. He is
That's not being
blurting out
Yes, you are.
information. He reverts back to subject matter jurisdiction. He accuses this court of
Mute
not
him.
honoring its oath. He just accused me of practicing
haven't.
law without a license. Again,
You
all
haven't.
attempts
No, I said
to
practicing law
deflect
from the
away.
bench.
I'm
I
going
said
to mute him
practicing
once
law.
again. This court has simply tried to no
Yeah.
avail to get Mr. Brooks to answer simple questions, confirming
He's refusing that.
on the record that he has been advised that he has a constitutional right to testify, and that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility.
And you know what? He's really mad because the judge didn't dismiss the case. Because he lied about the throttle body malfunction. He didn't have no evidence of that. He wanted the case dismissed. She wasn't doing that. That's why he's acting like that. Because he's mad it didn't go his way.
Not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these
That's all it
proceedings.
ever was,
He reverts
Darrell.
back, again, to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full
Right,
of
and that's the
his
wrong venue.
tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence
he ain't.
or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he
Wouldn't do it.
heard that or not. And based upon pursuant to State versus Anthony, and looking at the balancing test that this court must consider, this court simply cannot allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue.
He's still fighting. Still arguing with
When
him.
looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed
It's
from
conduct.
the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence.
See, the judge had to be politically correct. Stubbornly defiant. I wish she could talk without a filter and call him a nigga. No. Stupid. You know what? See, I ain't got no filter. We ain't in court.
Rules of procedure. As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules of procedure. The
Right.
court
So now,
in Anthony cited the U.S. Supreme Court from Arkansas versus Rock, wherein that court stated the right to present relevant testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process.
you know what I hate about this was like she's going over this and going over it and going over it, and I know she has to get it down for the record, although the record speaks for itself. Because I don't really think is that excuse me, it's really not that necessary given the fact that the Court of Appeals is going to review this and they're going to see the buffoonery that went on in this case, that Judge Dora was doing things, you know, that it was clearly obvious that we see. You really didn't have to do that. And so the point is, she's going over case law. He's not listening to that. That's just going in one ear. Well, I guess that's it because he can only hear out of one ear, right? It's only going to one ear. And so what I'm saying is, and I'm going to leave it at this. I want to hear your comments on this. What I just okay, so the point of this is really the temerity. I'll point out the temerity. The temerity that he had thinking or having an inclination that the judge was going to throw out this case because he did say it should be dismissed based off of the, watch this, the quote unquote exculpatory evidence. That's what he used. That's what he said. He didn't use it. He didn't use the scope. He didn't have it, but that's what he said. That's what he alleged. That's what he asserted. That's what he claimed. And it was proven that it was facts, not in evidence. He didn't have it. He didn't have it. But I like how the state came prepared. And like I told y'all earlier, it seemed like the state, they over prepared for this. It was over preparation. I mean, they went over this, man. He didn't have a chance. So, all right, listen, I want y'all to leave your comment. I know I talked a lot in the beginning, but I didn't know that it was going to take a while for the judge to come on out. But she finally did. And you can just see the anger, like when things don't go his way. Let me ask you a question. Now, can you imagine now if he can act like this in front of Judge Duro, considering that things weren't going his way? Could you imagine how when he wanted that money from Erica and things didn't go his way, what did he do? He punched her in her face, blackened her eye because it didn't go his way. He didn't get the money. So can you imagine how he really is when things don't go his way? Well, we seen it played out in the courtroom. The Court of Appeals is going to see that. They're going to tell Judge Dura, don't even worry about it. You didn't even have to go over that case law. We see this before. So, but let me hear what y'all got to say. Come on, y'all. Y'all been wanting me to upload down book stuff. Here it is. Here it is. Please like and share. Appreciate all the new subscribers that are coming on. And we are going to build this to the crescendo in light of the expectation. Thank you.